Hey, good afternoon. My name is Shonda Talene. I am one of the consultants from the Patton Harrisburg office, and I'm joined here with my colleague, Ronnie Russell. Ronnie, do you want to introduce yourself?
Yes, good afternoon. I'm glad to have all of you. We weren't sure about our Zoom link, so we're glad to see that you're all here. Again, I'm an education consultant with Shonda at the Patton Harrisburg office, so we're welcome to have all of you.
All right, so thank you for coming to our final installation of Coffee Breaks this year, and we are focused on manifestation determination today. If you have questions, there is a Q&A function, so please, if you have questions about the content, use the Q&A. I will be manning that while Ronnie is presenting. You can also use the chat to panelists. We're going to start off. I'm going to take you out to the website and show you where you can access the materials for today and previous recordings. So once again, thank you for joining us today to learn a little bit more about manifestation determination. So I'd like to start off by talking about the mission. The mission of the Pennsylvania Training and Technical Assistance Network is to support the efforts and initiatives of the Bureau of Special Education and to build capacity of local educational agencies to serve students who receive special education services. And our commitment to the least restrictive environment. Our goal for each child is to ensure individual education program teams begin with the general education setting with the use of supplementary aids and services before considering a more restrictive environment. So today we are here to talk about our two publications to support you with manifestation determinations. And those are the manifestation determination worksheet as well as the manifestation determination card. And I want to show you where you can find those on our website. So I'm going to take you out to patton.net. On our website up here where it says publications, if you just select that, and you scroll down, you can search by specific publications if you know, or if you know a keyword, you can search that way. So I'm just going to put in manifestation. And you can see I was searching earlier and hit go. And you will see the two publications that we are referring to today. So if you like, you can download those and have electronic copies, but you can also contact Patton and we can send you hard copies for your teams as well. Since we're here, I want to show you how you can locate the previous recordings for coffee breaks. So if you go over to supports and you select special education leadership and select coffee breaks for special education leaders and scroll down, you'll see the topics that we've had throughout the year. And if you continue scrolling down, you can see the recordings for previous sessions for this year, as well as the previous school year. Okay, so we are going to start with the content, and I'm going to stop share and allow my colleague Ronnie to take over.
Okay, thanks, Shonda. So we are going to talk about manifestation determination today. And before we go get started into that, just to remind you that this was first introduced with the 1997 amendments to IDEA and has stuck ever since then. We are hoping that we have new IDEA regs soon, but I'm not sure when. Our last ones were in 2004. So again, when should a manifestation determination be completed? And it is also known as a manifestation review, determination review, or MDR. What's important here also is to remind you about a particular case that you can Google if you're so inclined after we're done here, is called Honig versus Doe. And in that case that actually ended up going from district court to the Supreme Court in 1988, it was based in California, which is the 9th district, and Pennsylvania sits in the 3rd district. But this case was in the 9th district. And it really fits to MDRs because what it does is if a student has a behavioral situation that they're being disciplined for, that school districts can no longer put them out without having a manifestation determination first. They must keep the student in their educational placement as designated in their individualized education plan, their IEP, until that MDR is completed. What was interesting about the Honig versus Doe case, again, it was back in the late 80s, started in 1987, and then was finalized in 1988. The original plaintiff, Doe, when this all came to fruition, was 24 years old, so it really didn't apply to him. But who it did apply to was another student in California by the last name of Smith, actually joined that lawsuit. And they were both students with emotional disturbance that were suspended indefinitely for violent and disruptive behavior. And actually this fit for Smith when it all came about because he was still only 20 years old. And again, through the Education Handicapped Act, it required that stay put. So really a good case to know about. And again, I'm just giving you a snippet of it, but you can please Google Honig versus Doe to look up more about it. And again, this just tells you more about schools cannot change a student's educational placement or remove them from school based on their behavior stemming from their disability. And again, an individual with behavioral issues that occur as a result of their disability shall stay put and remain in his or her current placement while review procedures are underway. So let's talk about the regulation around manifestation determination. IDEA's discipline procedures require an LEA to conduct a manifestation determination review when disciplining a student. The purpose of this review is for the local education agency, parent, and relevant members, and we'll get into more of what those relevant members means, of the individualized education program team to conduct a review to determine if the behavior that is subject to disciplinary action is directly related to the student's disability or manifestation of the student's disability. What is considered a disciplinary change of placement? As you can see here on the screen, a disciplinary change of placement occurs when a student who is receiving special education services is excluded from school for more than 10 school days in a row, for more than 15 school days in any one school year, when 11 to 15 constitute a pattern of exclusion. And again, that's team-based. That pattern could also be before that 11th day. So again, a team really needs to look at that if you have a student that is having that disciplinary change of placement, and what does that look like. For even one day of school for a student with an intellectual disability is a disciplinary change of placement. And so when we look at the purpose of this review is to determine whether or not the child's behavior that led to the disciplinary infraction is linked to his or her disability. And that's why we do this manifestation determination. So when we talk about weapons, drugs, and serious bodily injury, LEAs may unilaterally, meaning that without consent of the parent, remove a student with a disability to an interim alternative education setting for up to 45 school days when the student carries a weapon, knowingly possesses or uses illegal drugs, sells or solicits them, or has inflicted serious bodily injury upon another person while at school. Again, it's really important here to talk about serious bodily injury a little bit further, as it really means a substantial risk of death or which causes serious disfigurement or protracted loss of impairment of the function of any bodily member or organ. Again, sometimes we see that students are disciplined for serious bodily injury to someone or to themselves. And really, it's not serious bodily injury. So just make sure if you are putting a student out in an interim alternative placement for up to 45 days for this reason, that it really was a serious bodily injury as per that definition. Additionally, when we talk about we're going to talk a little bit more about what we mean about weapons and what does that look like in regards to when we carrying a weapon to school. And so basically it's possessing a weapon at school, on school premises, or to a school function under the jurisdiction of an LEA. And in this case, the term does not include a pocket knife with a blade of 2.5 inches or less in length. A weapon, again, is a device or instrument, a material, substance, animate or inanimate, that is used for, is readily capable of causing death or serious bodily injury. Again, the LEA must notify the parent, and this term does not include that pocket knife. So again, that is in the definition of a weapon, but just something to keep in mind when you are looking at this interim alternative ed setting and unilateral placement before you put a student in that placement for up to 45 days. So now let's talk about the MDR team members, the manifestation determination team members. Malloy in 2008 tells us that manifestation determination teams must evaluate the relationship between a single behavioral occurrence and the student's disability, and then support the decision they've made with evidence consequently. Manifestation determination teams are urged to review all relevant data to include all IEP team members who have knowledge of the student or his or her behavior across settings and time. So really including everyone that would have that data to really focus on why this behavior could be occurring, if it is a pattern, et cetera. So the role of the school psychologist, and what we found as we talk to teams and train folks on doing a manifestation determination, is oftentimes folks are not including their school psychologist as they should be. We found that the National Association of School Psychologists recommends the inclusion of school psychologists on an MDR team. They have considerable expertise in comprehensive assessment and intervention, and they also have extensive training in multidimensional assessment to capture possible factors that are causing the underlying issues with the student's behavior. And as you see here on this screen, being a member of the manifestation determination team is really key for the school psychologist. They can really assist the team in gathering pertinent and necessary information, making informed decisions, and really considering the student's needs. And providing guidance, looking at data to assist the team in making that decision, and then recording it at the IEP team meeting. So 2 questions to assess when we look at the manifestation of behavior is, was the behavior caused by or directly and substantially related to the student's disability? And 2, was the behavior the direct result of the LEA's failure to implement the IEP? And believe it or not, manifestation determination is one of the most litigated areas in Pennsylvania when we talk about special education. And most often it is because the LEA's failure to implement the IEP was occurring. So let's look a little bit further at what Malloy from 2008 tells us about data sources and how they can help us in answering those 2 questions in the MDR process. So looking at the information source, what can teachers and parents tell us? They can tell us of a record of past behaviors at school or at home in order to determine if there's a predictable behavioral pattern or evidence of behavior under similar circumstances to this incident. Again, the teachers and the IEP of the student can really look at the positive behavior change and their implementation if there is one. The teacher and the actual behavior of the student, we can see if there's antecedents or an antecedent to this incident per the understanding of the student and the observers looking at the student. Really, really important to have the parent engagement. We can't say that enough in regards to health or medication information that could impact the behavior at issue. A lot of times when we see behavioral incidences occur, it's because of a med change or a med management that's going on for the student. And sometimes the school district is not aware of that. So again, something to consider. Again, teacher and parents, are there recent changes in the family or in the school experience that could negatively impact behavior? The time that we are all in right now could be something exactly where you're going from a virtual setting to an in-person setting. You might see some negative behaviors that otherwise you did not see just because of transition to a different setting. And then the student, what is the emotional status of the student, including his or her understanding of the incident? So what does that look like? So again, looking at that first question, was the behavior caused by or directly and substantially related to the student's disability? So we really need to look at as a team and decide whether the student had a significant ability that may result in impaired judgment or reasoning. Did they or did they not have that ability? To determine the effect of the information of their behavior, is there evidence of a direct relationship to the student's behavior? Their social emotional learning. Determine whether the student has a neurological impairment or medical condition. Oftentimes there are things going on with students that you can't see, but they are going on neurologically for them, and that does impact their behavior. Determine whether the student has shown a history of voluntary control of the behavior in question. So again, if there's not a pattern of these things happening, really diving into the data to see where is this behavior stemming from. And determine if the student in an escalated state is able to recall the knowledge to produce the ability to perform the skill. So really looking at how does this behavior, how is it affected by their disability? And again, as I mentioned, one of the most litigated areas in our state is manifestation determination. And again, was the behavior the direct result of the LEA's failure to implement the IEP? We see this often. So really something to focus on. Determine if the student was deriving reasonable educational benefit from their program. So not just writing a positive behavior support plan and ignoring it, but really using it as a living, working document and going back to it often, making sure that everyone has access to it, especially your students that are in the general education environment. Do all of those teachers have access to, or are they aware of that student's behavior plan? Determine if the student's needs were being addressed through the IEP. Determine if a positive behavior support plan was present. Was it appropriate and was it being implemented with fidelity? Again, if only one person knows what the behavior plan is, and the incident occurs in another classroom, a different setting like the lunchroom or something, and folks aren't aware of the positive behavior support plan this child has, it might not be implemented with fidelity. So just something to think about. Again, review progress monitoring data, not just behavioral, but academic. You might see that something's going on with the student. And again, just pulling data from all of those relevant members of the team for that student. And again, are there necessary resources available as part of the student's program to ensure that they're getting everything that they need? So if you have the handout that Shonda shared with you, that manifestation determination patent publication, you don't have to have any of this memorized. As a previous mentor of mine always said, just so you know where to find it. Here's the manifestation flow chart. When you flip open that pamphlet, it is on the first page. And so looking at the left column there, if the answer to either question is yes, to the behavior as a manifestation, then the IEP team must either conduct a functional behavior assessment, or if a positive behavior support plan already has been developed, review that positive behavior support plan and modify it if necessary to address the behavior and return the student to the placement from which the student was removed, unless, of course, you and the parent agree to a different change or agree to a change of placement somewhere else. If the answer to both questions is no, the behavior is not a manifestation of their disability, then the student may be disciplined in the same manner as a student without a disability who has violated the same or similar code of conduct. So again, you don't need to memorize this, but it is in that pamphlet on manifestation determination on the first page you turn over. So under Pennsylvania regulations 14.133 Prens H, an FBA must be conducted when the school refers the student to law enforcement, when the student is removed from their current placement as a result of that weapon possession, illegal drug possession, or serious bodily injury or harm, and when a student is removed from their placement for more than 10 consecutive or 15 cumulative school days, and the behavior is determined to be related to his or her disability. Again, under our state regulations, chapter 14, subsequent to a referral to law enforcement for students with disabilities who have that positive behavior support plan, an updated FBA and positive behavior support plan is required. And again, that falls under chapter 14, positive behavior support. Just a reminder of a free appropriate public education. More than 10 school days in a row or more than 15 cumulative school days in a row, the LEA must provide services to the student, meaning a free appropriate public education. Less than 10 school days in a row and less than 15 cumulative school days, the school system is only required to provide services to the student if it provides services to children without disabilities who are similarly removed. And again, what you see there is the federal regulations for IDEA. And once the removal is a change of placement, the IEP team would determine the appropriate services. The thing to note here is that IDEA 2004 makes it very clear that a free appropriate public education must be made available to students eligible for special education, including students suspended or expelled from school. So again, just a reminder that that doesn't exclude them from receiving their education. And so just a little bit more information about expedited due process hearings. So an expedited due process hearing is held when a parent requests a hearing to dispute a local education agency's determination that a student's behavior was not a manifestation of the student's disability, or a parent might request a hearing to dispute that disciplinary exclusion that constitutes a change of educational placement, like we saw in the Honig versus Doe case that I spoke about at the beginning. And a parent requests a hearing to dispute an interim alternative educational placement of no more than 45 school days ordered by the LEA, or an LEA requests a hearing to establish that it is dangerous for a student to remain in the student's current educational placement. And the only thing I also want to note here is in number 3, when we talk about, we've said it a couple times now, that up to or no more than 45 school days. If you do have a student that's going out to an alternative placement, you need to make sure that they have certified special education teachers, that they are actually having their IEP implemented if they, are a student with an IEP, as we're talking about. You really need to ensure that that's occurring. And then this just tells you a little bit more about our Office for Dispute Resolution. And how these decisions and considerations are for reflection on looking at hearing officer decisions. So ODR provides the resources for parents and educational agencies to resolve educational disputes for children served by, our LEAs and with disabilities or thought to have disabilities. So again, another resource for you to look at. You can actually do a search based upon topic areas. So you can actually do a search on ODR's site to look at cases on manifestation determination and how they were decided. Again, unfortunately, a lot of them that we see are because the positive behavior support plan was not implemented or an FBA was not conducted. Again, remember your FBAs must have parental consent. Again, we are not talking in depth today about functional behavior assessments, but again, we have a pamphlet on that, and all of that information is included in that. Again, as Shonda said, here are the patent publications, and you can search for those on the patent website. And then some other references. So you see at the very top there, that's a reference to our federal regulations with the Individuals with Disabilities Act. And then our 22 PA Code Chapter 14, which is our state regulations, and 22 PA Code Chapter 15. And then you can see the Pennsylvania Department of Education manifestation determination, where the patents handout is, the worksheet, and then the definition of a weapon and where I actually got that from, or we got that from under the United States Code.
All right, thank you so much, Ronnie, for sharing that information. And we do have a couple of questions for the Q&A. So the first question was about the PowerPoint slides. They are not available because all of the information is contained within the two publications that we shared with you. So the worksheet and the additional pamphlet has all of the information from the webinar contained within those. And you can access those on Patent's website under publications by searching for manifestation. Okay, Ronnie, there was a question, and my esteemed colleagues who are also in the webinar, please feel free to chime in as well. So Stephen asks, is the district allowed to say we are not suspending the student because we are providing live streaming? So I'm assuming that the student is at home, but they are participating virtually. This is something that I have heard, and I feel like regardless, it is still a change of placement. So thoughts on the situation?
So again, tell me again, the student has a disciplinary.
So I believe the question is if a student is being asked to stay home and participate virtually, would that be considered a suspension?
Yes, and it might be something to consider. Something that we talk about when we do training for our principals is doing in-school suspension and really ensuring that the student has access, if you can, to their regular peers and curriculum, et cetera. If that's a more least restrictive choice, if you will. But again, I think to answer your question, yes, it would be a change of placement, as Shonda said.
Are there other questions regarding the content? You can use the Q&A. I did also want to take advantage of the fact that you all are here, and we are beginning to plan our coffee breaks for the 2021-2022 school year, which is right around the corner. So we put in the chat a link to a short survey to get your feedback on coffee breaks and also possible topics you would like to have covered in these shorter sessions. So if you feel so led, please utilize the link in the chat to complete that short survey. And if you have additional special ed leaders you would want to share the survey link with, please feel free. We are still here for questions. Okay, the link says you need access. Let me take care of that right now. So Ronnie, can you see if anyone else has questions?
No, I don't see any more questions.
Okay. So.
Again, I will say if you have not printed out that worksheet on manifestation determination, please do so. Please share it with your school psychologist. If you would actually like printed copies, you can actually request those on Patton's website. If you don't want to print them out or don't have capacity to print them out, they can actually be sent to you. If you're doing a training maybe on manifestation determination, or even FBA if you want that handout. Again, with any of our handouts that we actually make in print, you can request those, maybe you're doing a training, et cetera. And make sure your school psychologist has them.
Thank you so much.